Welcome back to your second lecture on finance. I hope that you had a very peaceful or restful holiday for Christmas. If not, then you can probably rest a little in today's lecture. I will give you a very short overview of Section 7 and LKWN and DD at the beginning. And then the rest of this lecture, I would say, is a bit extra for your purposes. You have your course material, your course manual as your reference. It doesn't go as far as I would in this lecture. So it's something for your interest, if you care to know about. But these are the things that I would personally deal with in my actual practice. I don't read LKW and DD anymore because I only know it too well. Okay, so I will be looking into specific case laws in relation to some of the factors in Section 7. I hope that it won't take too long for me to go through these slides. In the very end, I will tell you about the requirements for a prenuptial agreement in Hong Kong. I think that's the only part that is touched upon in your course manual. But I think the summary or the statement that is given in your course material is incorrect as a matter of law. That's not how I understand prenuptial agreement and the case of SPH. But I don't think it would be examined for you. Okay? And in the very end, in today's lecture, you should have the last set of slides prepared for this course. You also have one piece of paper of 2 pages, which is the factual scenario I've devised for the ADR course. So in the end, if we have time, I think we have time, I will explain to you how I have come to the proposal for the husband and the wife in that factual scenario, so that I hope that you will have an opportunity to see how LKW and DD can be applied in a case like that. Okay, but that's just my personal view of these facts, and there's no research involved. It's based on my experience and understanding of the law. Okay? So, the Section 7 factors, it's in Section 7, subsection 1 of the MPPO. The exercise of Section 7 is a matter of fact-finding based on these elements. And with that fact-finding, the court would exercise its discretion in coming to a fair result based on the steps and principles in LKW and DD. So in A, you have income. So that refers to your actual income or income that you are likely to have in the foreseeable future. Okay? Remember that you have to pay attention to the last bit of A and also B. You have to refer to what the party has currently and what the party is likely to have in the foreseeable future. Earning capacity. Okay. Earning capacity is not earning. It's how much you are able to make, the ability for earning, not earning per se. Okay? So even if you have a current earning of, say, $20,000 at present, it doesn't mean that 20,000 is your earning capacity. If you have a highly educated background, then the court might think that you have an earning capacity of more than 20K, maybe 30K, maybe 40K. Okay? And then you have property, other financial resources. Property can include all sorts of properties. It can be a flat, it can be savings, it can be valuable items like watches, jewelries, yachts, and cars. It can also include insurance. It can include shares. Okay? And I will talk about other financial resources later in this lecture. B, financial needs. You can simply understand financial needs as the husband's and the wife's monthly expenses. Okay, in simple terms, they refer to things like your rent every month, how much you spend on food, how much you spend on transportations, clothing, grooming, entertainment, holiday, medical needs, those sorts of things. It would make sense to you if you look at the financial form, which is called the Form E. And I will take you through the Form E in the third lecture on ancillary relief. Okay? Needs are to be generously interpreted. So needs is not confined to reasonableness. There is, so you remember from last class, since White and White and LKW and DD, there is no longer the limit of reasonableness in assessing one's needs. Okay? So the law is that the needs is to be generously interpreted. Obligation and responsibilities. Obligation can include those you owe to dependents, such as cohabitees and children. Okay. Responsibilities, they can also include debts, okay, such as loans you have borrowed from somebody. And there is a usual argument in finance cases in a divorce that certain loans, if you borrow from, say, your parents, the husband's parent or the wife's parent, or if you borrow from your siblings, then the other side can argue that the loan is a soft loan and it can be disregarded. Okay, because the loans would bring down the net asset on the side of that party. Okay, if you say that it's a soft loan, then it will increase the asset under the name of the other party. Standard of living. It is more important to maintain the same standard of living enjoyed by the party during the marriage for the children. It's more important for the welfare of the children, not so important for spouses. And that's because maintaining two households would inevitably be more expensive than maintaining one. Okay? So if children is not an issue, then it's very likely that the parties would have to compromise in their living standard in going forward. Okay, because you're split into two households, it's more expensive, simply. Okay, but when there are children involved, you have to be careful that there should not be significant disparity in terms of wealth between the two households. Because you don't want to give the impression to the children that one of the parents is doing better than the other. So you won't, it's very undesirable if the court comes to a conclusion where you have a father living in the mid-level, whereas the mother is living in a public housing situation. It is not desirable. Because in the mind of the child, he would think that my dad is really rich and my mom is really poor, and I would prefer my dad for that reason. It's not good. So D for the age, the parties, and the duration of the marriage. Age would have an impact on a party's earning capacity. It would also have an impact on the party's medical needs. These are just common sense. For duration of marriage, you would know from LKW and DD that for a short marriage, it is actually a good reason to justify departure from 50-50 if sharing is applicable. That's especially when an asset is acquired independently from the marriage. okay, or in the case of unilateral asset. So usually when you apply the yardstick of equality, you are 50-50. The most you can depart from that 50-50 would likely be 40-60, or in an extreme case, it might be 30-70. But when you have a short marriage, and then you have non-matrimonial assets, okay, with the source of assets being a material factor for departure, then it is not unlikely that you would arrive at 10%, 10-90 or 15-85, that kind of division. But you should know that for duration of marriage, cohabitation prior to the marriage will be taken into account. So cohabitation would mean that if the parties live together in circumstances which approximate to cohabitation as a married people, with a married couple, okay, the cohabitation has to seamlessly move to a marriage. Okay. So student romance would not count as cohabitation. And usually, the way you calculate duration of marriage is you start with cohabitation or the date of marriage, and then it ends when the parties separate. Okay. It doesn't end on petition date, it ends on separation. Physical and mental disability in E, they are self-explanatory. They are part of the consideration of needs. Okay? And needs is also a material factor in step 4. Contribution. Contribution includes financial contribution and non-financial contribution. Contribution to the welfare of the family and the children. I will look into contribution in greater depth later. And in G, in the case of proceedings for divorce, the value to either of the parties to the marriage of any benefit, for example, a pension, which by reason of the dissolution of the marriage, the party will lose the chance of acquiring. So it's about loss. And loss of pension is one of the examples provided in the statute. There is also this thing that we call relationship-generated loss. Okay, and it's one of the subtopics in today's lecture as well. So these things of Section 7 factors are all fact-finding based on the available evidence. And there are some specific issues giving rise to some case law that we lawyers would have special considerations of when situations arise. Okay. Do you still remember this slide of LKW and DD? Yeah, I'm putting it here just as a reminder for your exam. I think this slide and the previous slide is all you have to memorize to, I suppose, pass your exam. This is highly examinable. They must appear in your exam, these 2 slides. In your course manual, I think the author has tried to categorize these Section 7 factors into 3 types. Okay, to me, they are not very helpful. Okay? It doesn't mean anything. But I think the reason why they were put into 3 categories is for to aid your memory for the purpose of the exams. But as far as I can read from those paragraphs, they don't really explain what these factors are. So I hope I have done that explanation better to you just now. Okay, so find a way to remember the Section 7 factors list. I think this is, well, I'm 90% sure that you will be asked to memorize these things. Okay, and then LKWNDD. Oh, I didn't put the 4 principles here, but you have 4 principles, 5 steps, 6 material factors for departure from equality. Okay, easy. Shouldn't be too hard. Okay. Okay, so with these things, you can now relax a little bit. Okay, see how much you can absorb in the following slides. They are slightly advanced, slightly complicated, slightly intense in terms of law. Okay, see if you can follow me. So the first topic is preliminary issue. This is actually a revision of your land law on resulting trust and constructive trust. So as you will see in the previous slide, and as you will remember from LKWNDD, the first step you need to know before making any adjudication on ancillary relief is the size of the matrimonial assets, the pot. The first step is to know how much is available for division. So I have a pie chart here to represent the matrimonial pot. The first step is to know how big this pie is before we can share and eat into the pie. Okay, so I think I mentioned this in last lecture. The starting position is that whatever that is under the name of the husband and the name of the wife would be put into this pot. So that can include your cash, shares, flats, yachts, cars, valuable items like jewelries, watches, and insurance. That would include landed properties, and of course. And if you are the legal owner of a flat, the legal owner, whether you own it solely or jointly, whether it's a joint tenancy or a tenancy in common, you have to disclose that and put that in the pot first. Okay? So if it is under your legal name, and you remember the difference between legal title and beneficial interest, that's when your name appears on the title deeds, when it's registered in the land registry. Okay? But apart from that's the basic, that's the starting point. But apart from what is under the legal name of the husband and the wife, from time to time, there might be issues with third-party interest in land. And that's what we call the TL and ML procedure, sometimes the preliminary issue. They're the same thing, okay, when we use these terms. The TL and ML procedure is an extra step within the step 1 of LKWNDD to decide how big the pie is. Okay? It's part of the exercise of identifying the assets of husband and wife. So what it would involve is that you would either add more into the pot and make a bigger pie for sharing by putting the asset under the name of a third party into the pot. And you would enlarge the family assets in total. Or you would cut the pie and take part of it out of the matrimonial pot by saying that the asset is not mine, but it belongs beneficially to a third party. The way you do it is by arguing resulting trust and constructive trust. So Stack and Dalton, if you remember. Okay. So in preliminary issue, you will see how land law interplays with family law. Okay. It would involve a third party who is not the husband or the wife, but they are usually somebody related to the husband or the wife. So they can be parents, siblings, and sometimes they can be friends of the parties. The dispute on third-party interest would be adjudicated as a preliminary issue. The preliminary issue is an issue on ownership, typically of landed properties, and it's preliminary to the identification of assets of the husband and wife. Okay? I hope it's not too complicated, just revision of land law. They are not mentioned in your course manual, so even if you don't know it, it's fine. You passed your land law exam already. But this happens more and more in practice in Hong Kong these days. Right. There are two possible scenarios. The first scenario is where the legal title of the landed property is vested in a third party. This is the situation of TL and ML. I have included the citation here at the bottom. TL and ML establishes the proper procedure for dealing with third-party interest in divorce context, and that's where you get the name of the TL and ML procedure. So to make it easier for you to understand, I will just assume that the third party is the mother of the husband, the mother-in-law. The third party, the mother-in-law, has the property. It is not in the pot. So by default, it cannot be claimed in the divorce by anyone. But the wife might want to claim for that property. She would argue that the husband the husband is actually the beneficial owner of that landed property, and his mother is merely holding it on trust for the benefit of the husband. The wife might say that the husband has paid for everything, so that's an argument of resulting trust. Or the wife might assert a constructive trust between the third party and the husband. And in this scenario, the burden is on the wife to join in the third party and to make the claim and to prove the case of trust. This is the principle from Stack and Dalton that equity follows the law, and the onus is upon the person seeking to show that the beneficial ownership is different from the legal ownership. Okay. Why would a wife want to litigate on the beneficial ownership of this property that is not in the matrimonial pot? Anyone wants to try? Why? It's not in the pot. Why does the wife want to drag in another party to claim for that property? Any guesses? Yes, that's correct. If the husband is the wealthier side and the wife would be the claimant in ancillary relief, by saying that the husband has more properties, then of course the wife can eat into more properties in the sharing, right? But even if the wife is the wealthier side, even if the wife has to pay the husband in the end of the divorce, if there's now in the husband's pockets, that means that the difference in terms of wealth between the husband and wife gets smaller. So when you pay out, when you adjust the properties, after you have the percentage, the wife can pay less out of her pocket. Because assume that you both have some properties, and then you will have a percentage after LKW and DD, assuming you have a sharing. But then you have to offset if I'm the payer, I have to take into account of what he already has before I pay out that amount to achieve the percentage. Okay. Does it make sense to you? Okay. In this scenario, the third party and the husband are on the same boat. They are both defendants. They will both say that it's the third party's property. There is no such thing as trust, and hence the wife cannot claim this property. And in this factual scenario, as in TL and ML, the wife has a very heavy burden to discharge. That is because if there is a deal between the third party and the husband, the wife is not privy to that deal. Okay, so how can she know about any such common intention between the third party and the husband if she's not part of it, right? And where can she find a proof of payment to support a claim of resulting trust? It's very difficult, and is always one version of the story by the wife versus two consistent versions of story by the third party and the husband. So this is actually quite difficult to prove in reality. But of course, if the wife doesn't apply to join in the third party, she cannot claim at all. Okay. The second scenario you have is the scenario of Fisher Meredith. This is much more common. And Fisher Meredith is another landmark case in third-party interest, as in English law. The judgment comes after Stack and Dowden. And in this scenario, the legal title is vested in the husband or in the wife, or in both the husband and the wife as joint tenants, or tenants in common. Okay. So in my example, the property is in the name of the husband. It falls within the matrimonial pot, and therefore it is subject to sharing, if sharing is applicable. Here, it would be the third party who would want to say that she is the beneficial owner and the husband is holding property on trust for her, by arguing either constructive trust or resulting trust. They're usually argued and relied upon simultaneously. Okay? So you have two alternative cases in case that the resulting trust or the constructive trust fails. So the third party would have the burden to prove the case. She needs to apply to join into the proceedings. And if she doesn't, then she runs the risk of losing the property of which she claims to be the true owner. Okay, because the property is in the pot. The husband is technically a defendant. Okay? The third party is the claimant. The husband and the wife would be both defendants. But for the husband, he would raise no meaningful defense. He would run the same case as the third party, agreeing to everything in the pleadings, saying that he's merely a trustee, he doesn't really own the property. So if the third party is successful with the husband's support, then the wife cannot claim that property, which is in the pot. The husband would also have the incentive to join in the third party, and procedurally he can actually join in the third party. He wants to drag his mother into the litigation because if he is the payer in the end, if he has to pay for the wife in the end of divorce, by pulling the property out of the pot, then naturally the husband has less assets to pay to the wife. Right? But even if the wife is the wealthier side and the husband would ask for payment from the wife, then if the husband now has less property under his name, then in the balancing, in the readjustment, in the payment, he would receive more from the wife. And as to the wife, she would usually argue that it is a gift to the husband when a third party is involved. This is a very classic situation of a fight between a story of trust and a story of gift. This is the typical scenario. I haven't told you about the procedural aspect of ancillary relief, right? But you would have had the flowchart from the children lecture, where remember, after you commence the proceedings by petition, you would have the first appointment hearing and the first children's appointment hearing at the same time. And then you would do the children first, so you would have the children's appointment, the CDR, the children dispute resolution, and the trial on children. And after that is resolved, you go back to the finance and then you revive with first appointment hearings. And then in the end, on the finance, it would be the trial on ancillary relief. Okay. The ancillary relief trial is where you would have the application of LKWNDD and the Section 7 exercise. If there are disputes on third-party interest, then at least in the past few years, there will be a separate procedure of TR and ML that happens somewhere between the first appointment hearings and before the final trial on ancillary relief. Okay. That's because before we can share the assets between the husband and the wife, we need to know what can be shared and what cannot be shared first. Okay. In preliminary issue, the law that we apply is strictly land law on trust. Resulting trust or constructive trust. The procedure is usually referred to as the TR and ML procedure. It implies that you will need to have pleadings. As in a civil case, you will have pleadings to set out your case, and then you will have witness statements at the trial as part of the evidence. It's just like a civil trial, and it's a civil trial on its own independently from the ancillary relief trial. Okay? And in the TR and ML procedure, there is nothing matrimonial about it. It's strictly civil, it's strictly land law. But in the ancillary relief trial, in the very end, the law that we apply is family law. That's Section 7 LKWNDD. The procedure is matrimonial procedure. So we will have the prescribed form of Form E to set out the parties' respective financial information. There is no pleadings. We also use a Section 7 affirmation instead of witness statements for the trial on ancillary relief. Okay. In practice, if there is a preliminary issue, the ancillary relief is very likely to already settle at the preliminary stage. That is largely because, in many cases, the property in dispute would take up the majority of family asset. So if you lose that part, then there might be very little left for you to share. So the whole ancillary relief matter would end there. And also, in many cases, the third party would be the father-in-law or the mother-in-law of a party. And that father-in-law or mother-in-law is also the person who has the cash to settle the case. So if you want to maximize your claim, you will need their blessing, the blessing from your in-laws. The preliminary issue is the proper occasion where you can negotiate with that third party who is now a party to the proceedings. You can have FDR with a third party, as well if there is preliminary issue. Another consideration is, of course, as always, litigation risk and cost. Preliminary issue itself, because it's a full trial on its own, it can burn a lot of money on legal cost. So if you lose, then you have to bear the cost of 3 parties. It can be very substantial. So if you burn all the legal costs there, you probably don't have the money to fight for the remaining of the ancillary relief trial. Okay? So this flow chart represents how things are done in the past few years. The preliminary issue would be adjudicated at the TNML procedure before the trial and ancillary relief. In the past few years, it's a common practice that has been adopted by family judges and followed as well. But there is this new practice direction, the PDSL 10.4. Okay, and it provides that the preliminary issue can probably be heard together with the ancillary relief at the final trial. So you don't have the second part. It will become part of the third part. I think this is this new PD is it only came into effect in September. It's 3 months old. It's pretty new. Nobody knows how it applies in reality when there's third-party interest involved. I think this is likely if there are only 1 or 2 properties in the pot and there are third-party disputes on these properties. Okay, because if the beneficial ownership are decided, then that basically decides the whole matter of finance between the parties. It is unclear under the new practice direction whether you need pleading. For me personally, I'm more inclined towards the requirement of pleadings because preliminary issue determines beneficial ownership. It's about whether you have the right to claim the property or not to begin with. But in ancillary relief, it is a matter of exercise of discretion. So even if you have the right to claim the property, you may or may not have it in the end. It's a matter of discretion. So I think it's important to distinguish these 2 things, and even if you procedurally have the 2 matters adjudicated in the same set of proceedings, to me, I think it's necessary to have pleadings. Okay. So again, this is not in your course manual, and it's basically land law, so I don't think it's examinable. But if you proceed to practice, you should be aware of it because it happens quite a lot, more and more these days in Hong Kong. Okay. It happens so much that the new practice direction has to mention about preliminary issue. Okay. Third-party assistance. The topic of third-party assistance arises from subsection A in section 7, subsection 1, where the court should consider other financial resources which each of the parties has or is likely to have in the foreseeable future. Third-party assistance is also very typical in Hong Kong, at least factually speaking. A common scenario would be something like this. For example, the husband comes from a very rich family, so that family would have a lot of assets. They are likely to be running some sort of family businesses. The rich family behind the husband would allow the husband and the wife to stay in a residence they have provided for free. The parents, that rich family, would likely pay for the wedding of the parties, pay for their holidays, their honeymoons. they might also settle the monthly bills for the husband and even the wife. But usually, there's very little asset under the name of the husband. So in a divorce in ancillary relief, the wife would say that she's used to a very high standard of living, so that her needs should be calculated in a very high amount. But the problem is the asset under the name of the husband will be very minimal. And the wife, probably she doesn't have much asset under her name either. And sometimes either they're not working at all and they only rely on the husband's family, or the husband or both of the couple might be working for the family, but they only receive a very modest income. Okay, so in these situations, if you go back to LKW and DD, the sharing principle would not apply typically, because there is no assets under the name of that couple. The assets are all held by the husband's family, typically. And if you are left with a needs case, the amount of money that the wife would receive would be very small. Okay? You always get less with a needs case than a sharing case. So it's always better if you can argue for a sharing case for the claimant. Okay. So if sharing is not applicable, you look at the needs of the parties, and the wife's needs is at the higher end. Even if the husband is working, he is likely to have very little income. And then the husband will need money to make his living as well. He can offer very, very little to the wife, and that definitely cannot satisfy the needs of the wife. So what can the wife do? The wife can argue that the husband has other financial resources from his family. Okay, that's what third-party assistance refers to. The case authority is KEWS and NCHC. It's a CFA decision. If you Google this case, you would know who the parties are. I know who they are, but I can't tell you. I know the husband personally. The husband has, since the divorce, remarried, and the new wife was once upon a time a pop star in Hong Kong. Okay, you just Google it and you will find out. What happened in KEWS is that the parties, the husband and the wife met in the early 1990s when they're still in their teens, and they eventually got married in 2000 in London. Unfortunately, in 2002, the wife was diagnosed with a very rare intestinal condition. Her condition was very severe, and when the matter came to trial in June 2010, the wife had undergone some 10 operations in the past 10 years, in the past 8 years since 2002, and during which a large part of her digestive system had been removed. She weighed 70 pounds only at trial. She was on very heavy medication and she was confined to a home. So you can already imagine that apart from that high living standard, she also has very high medical needs. The husband is a Harvard graduate. He also has a EMBA degree from the HKUST Business School. There was evidence saying that the 3-year average annual salary for the graduates from this school was USD 465,000 something dollars per year. Okay. The husband comes from a very well-known family in Hong Kong. They are not extremely rich as adjudicated by the trial judge, but the family of the husband has been supported the couple's life prior to their separation in 2006. And since the separation of the parties, the husband's families continued to give support, financial supports to the husband. The financial supports included the payment of the wedding reception of the couple at Shangri-La and the couple's credit cards bill. The husband also received $7 million in his account between 2005 and 2010, but he was only making $400,000 over that course as salary. And meanwhile, the husband has withdrawn from his account some $8.28 million. His monthly salary was $14,000, but his monthly spending on average was $45,900. Okay, so what he makes and what he spends do not match, and that's because everything is paid by the husband's family instead of the husband itself. The case went to the CFA, and in the end, the CFA upheld the ruling of the Court of Appeal, saying that the husband has underutilized his earning capacity with his qualification, and his income at the time of $14,000 was unacceptably low, because he's a Harvard graduate and he also got an MBA degree from HKUST. The husband also received financial support from his family, and this is likely to continue. On the other side, the wife has needs in the amount of $42,500. So the husband, in the end, was ordered to make a periodical payment in that sum. There's also a further lump sum of $1.5 million ordered to be paid to the wife. Okay. So even though the husband was making $14K a month, he was ordered to pay $42K to the wife every month. Partially because he can have the help from his family. The legal test on third-party assistance is twofold. Firstly, what is the extent of the financial assistance provided by the third party to the husband or the wife? And secondly, what is the likelihood of such financial assistance continuing in the foreseeable future? Okay, and it goes on at paragraph 37 that the court must look at the reality of the situation and have regard to matters of substance and not just form. Okay, the court can take into account not only what a party actually has, but also what might reasonably be made available to him or her if a request for assistance were to be made. For what might occur in the foreseeable future, you can look into past conduct, which performs as a useful guide. So in this case, it was said that the husband should have an earning capacity of $42,500 a month. As I said, earning capacity is not actual earning. His actual earning was only $14K. But with his qualification, his educational background, and his experience, the court says that he has an earning capacity of $42,500 a month. That's his earning capacity. The point of third-party support is that even if, now assuming that the husband has that earning capacity of $42K per month, and even if the whole of that earning capacity is given to the wife, the husband will still be doing fine with the help of his family. Okay, so third-party assistance is not an order asking the parents to pay to the spouse, but it proceeds on the footing that even if you have paid the whole of your earning to the other party, you will have the support from a family to support your life. Okay, it's not asking the parent to pay to the spouse directly. Okay, the thing you should note about third-party assistance is that it only applies in a needs case. If the pot is sufficient to satisfy the needs of the parties, that sharing principle would apply, and you can't argue third-party assistance in a sharing case because you don't need to. And you always get more by sharing than looking at the needs. Okay, do you have any questions? This happens quite a lot in the families which are in middle class, but the higher end of middle class. It doesn't happen in big money cases, but for middle class cases, more likely. Other financial resources in subsection A can also include bonus. Bonus usually are annual bonus, but as you know, bonuses are usually discretionary. So you have to see if you want to claim, if you want the court to take into account the bonus, then on evidentially, you would have to find a pattern showing that the party has been steadily receiving bonus at more or less the same level or increasingly. Okay. Other financial resources can include inheritance. To claim into inheritance, you will need clear evidence that this will likely be an inheritance received by the party. You can't just say that the party has a chance to receive inheritance, because by operation of law, everybody has a chance of receiving inheritance. Okay. You need some evidence. And after the parties have separated, the inheritance would be less significant. Okay, because if you have separated, then whatever you get, including inheritance, might be treated as non-matrimonial. And the inheritance itself is not matrimonial at all. It's something very extra. It has nothing to do with your marriage. It's because somebody has died. Okay. So in the case of A, B, and MA, the wife's parents were in their 70s. They were in good health. And there are a large number of possible beneficiaries who can feature in her parents' will. It cannot be foreseen when and what the wife would inherit from her parents. So inheritance was not taken into account. There must be something very solid and supported by evidence in order to claim into inheritance. Stellar contribution or special contribution. The argument would arise when a party seeks to persuade the court that his or her contribution to the family welfare is significantly greater than the other party's, so as to justify the departure from an equal division. Okay. There are some paragraphs in LKW and DD that discuss about special contribution. If you're interested, you can read about them. Okay. In principle and also in reality, the court is very reluctant to find stellar contribution for departing from 50-50. That is because amongst the four principles in LKW and DD, there is rejection of discrimination. the husband and the wife are presumed to share their roles in building the family and contributing to the family welfare equally. You can't simply say that one has contributed more than the other, okay, because you made financial contribution. There is also the principle of rejection of minute retrospective investigations, principle number 4. And if you are a breadwinner, when you have a breadwinner and a homemaker, you can't simply assess and compare the parties' respective contribution to say that which one is greater. Okay? The two things are inherently incomparable. Okay? One is financial, one is not financial. The comparison and the assessment would then involve retrospective investigations, and that is contrary to principle number 4. Okay. There is also the risk of double counting by looking at stellar contribution. Contribution has already been considered in the 50-50 split. The reason why we have yardstick of equality is because we have recognized non-financial contribution. Okay? So after you have applied 50-50, and if you seek to argue contribution again, then there is a potential risk of double counting. So for these reasons, it's only in very rare and exceptional cases that you would have departure from 50-50 on the basis of stellar contribution. Okay. So in reality and for practice, you might as well treat it as a non-creature. It doesn't really exist in reality. In the first case of ML and YJ, the whole pot amounted to some $840 million. The husband didn't advance an argument of stellar contribution, but it was actually the judge who had invited the parties to consider whether the total wealth of the family on its figure alone would warrant departure from equality on the ground of stellar contribution. Okay. The husband didn't raise his argument, but given the size of that pot of $840 million, the court asked the parties, would you consider this? And the judge said in the second judgment that one must primarily examine the manner of the generation of the wealth instead of looking at the amount of the wealth. Whilst an extraordinary amount would make it easier to advance a claim of special contribution, one must still ask whether the wealth was generated from exceptional quality of the breadwinner. Okay, so whether you can argue stellar contribution or not does not depend on the amount of the wealth, okay, but the manner of the generation of that wealth, whether it was because of some exceptional quality of the money-making party. So in the end, in this case, the 50-50 sharing is appropriate, as it was ruled by the judge. It's not a short marriage. The wife had contributed to the family both financially and domestically. The wife had given up her businesses for looking after the children, and she will continue to do so. So in this case, simply it's a 50-50 split. In Chai and Pang, the husband has been a hugely successful entrepreneur over many years, and he had managed to build up a complex symbiotic web of entities. The worth of that entity was £66 million. The wife says it should worth more, of £153 million. But in this case, again, no special contribution was found. That is because the husband's so-called stellar contribution is not sufficient to outshine the wife's role as a mother and homemaker. The harder the entrepreneur breadwinner had to work at his business, the more the responsibility of childcare and domestic infrastructure would have fallen to the homemaking wife. Okay? It makes sense to you? And in this case particularly, one of the children has some sort of neurodevelopmental disorder, and the other child has autism. The burden on the wife in this case to take care of the children and the household was actually very, very high. Okay. In W&H, the trial judge found that the substantial assets had been accumulated through the husband's application of his financial skills. The extent of the assets were derived from the husband's effort, and it exceeds what might normally be considered as mere income. So it would be inequitable to disregard them and not treat his skills as special contribution. That's what the trial judge said. Okay, the husband has made so much money, you have to take into account his exceptional skills in generating those monies. The trial judge found stellar contribution. But then the case went on appeal and the point was overturned. The Court of Appeal said that the evidence has shown that the funds of the husband's companies under his management might have outperformed the benchmark in the past, but it is wrong to categorize the husband's talents as stellar. He was good at his job, but the highest it could be put is that he was better than most or above average. So finance is his job. It's his job to make that amount of money. It only means that he's very good at it, but it doesn't make that quality stellar or exceptional. Okay. So special contribution was not engaged. It was overturned at our Court of Appeal. Okay. So these are all examples where there is no special or stellar contribution. So what would qualify as stellar contribution so as to justify a departure from 50-50? The standard is that the contribution, the quality, has to be so exceptional that it makes it inequitable to not to have regard to the contribution. The wholly exceptional nature of the earning must be obvious and gross. Okay? Gross doesn't mean gross in the usual sense. It means it's so significant you can't ignore it. Okay? Those characteristics or circumstances clearly have to be of wholly exceptional nature, such that it would be very obviously be inconsistent with the objective of achieving fairness for them to be ignored. Okay? So it has to be to the extent that it would be unfair if you don't take into account of the stellar contribution. Okay. So if you go on to read more about family law, from time to time you will encounter the argument of stellar contribution or special contribution, but it rarely succeeds in application. And hence you might as well treat it as non-existent for your purpose. Okay? Don't get excited about this argument. It rarely works in your favor. Okay? So I will do a little bit on compensation and then I will give you a break. Okay? compensation, if I remember correctly, that's element G. That's compensation for the loss by virtue of the dissolution of the marriage. The example given by the statute is the loss of pension. But apart from that, there is also what we call compensation for relationship-generated disadvantage. The term was coined in the famous case of Macfarlane by Baroness Hale. Okay, you know Baroness Hale, Lady Hale, right? She wrote Staggered Dalton in Trust. In Macfarlane, the wife was a lawyer with a leading London firm, and then she gave up a career to become a full-time mother. She has been devoting her time and energy to the family, and she has been supporting her husband in his career as an equity partner at a firm. But at the same time, because she has given up her career, her earning capacity has diminished over the years. So it is said here at Macfarlane that a second rationale, which is closely related to need, is compensation for relationship-generated disadvantage. Indeed, one consider that provision for need is compensation for relationship-generated disadvantage, but the economic disadvantage generated by the relationship may go beyond need, however generously interpreted. The best example is a wife, like Mrs. Macfarlane, who has given up what would very probably have been a lucrative and successful career. If the other party, who has been the beneficiary of the choices made during the marriage, is a high earner with a substantial surplus over what is required to meet both parties' needs, then a premium above needs can reflect that relationship-generated disadvantage. Compensation reflects double loss of a wife. The loss of earning capacity of the wife, and also a loss of a share in the husband's enhanced income. In this case, there was insufficient capital to award to the wife. So meaning that it's a needs case, sharing cannot apply. So the wife was entitled to substantial monthly maintenance for herself and for the children. You have to be aware that if in a case where sharing is applied, then there is a risk of double counting, because the loss of earning capacity would have been calculated and factored in applying sharing. But there is no issue with double counting here, because the compensation, the ancillary relief, was given in the form of periodical payments. Okay, so it's a similar risk with contribution. Contribution and compensation for loss have already been addressed by sharing as a matter of principle. So in fact, compensation for relationship-generated disadvantage is quite rare for sharing cases. It's something that you can probably argue in a needs case, such as in Macfarlane and Macfarlane. In WLK and TMC, so the precaution in considering relationship-generated disadvantage is enunciated in the paragraphs I have extracted here. Okay, that's basically what I just said. Compensation in this regard is usually factored in when applying the sharing principle. It would only be in exceptional cases that a separate and a further element of that award should be dedicated to such compensation. And if you decide to put a little bit more in the name of compensation for relationship-generated disadvantage, you apply a broad brush attribution of some percentage to represent the element of compensation. Okay? You don't do meticulous calculation. It's a rough percentage you will add on top of the sharing. So in this case, the wife has decided to forego her career as a concert pianist to accept the role which was preferred by the husband in the marriage. The husband has encouraged the wife to travel with him and not to pursue her career. It was accepted that there should be some compensation in this case, but because the aspiration of a career as a concert pianist involved a high degree of uncertainty, so the allowance should not be so great. By applying a broad brush approach in calculating that sum, a small percentage of 3% of the total asset was allowed, okay, on a rough and ready basis to recognize the relationship-generated disadvantage. So it's very small. There is a very recent case from the UK called Alsey and JC. It's a decision from 2020. It's similar to McFarlane, where the husband was a solicitor and a partner in a Magic Circle law firm in the litigation department. The wife, she was a solicitor, but she had not practiced for some years, and she was, at the time of the litigation, a housewife and a homemaker. The wife was actually a trainee at the same law firm as the husband. She was qualified in 2001. The relationship commenced in 2002, 2003, and shortly after, the husband became an equity partner. The wife was promoted to be a managing associate in 2006. The parties were engaged in 2007, then the wife moved in-house to a bank later. The matrimonial assets of this case amounted to about £10 million in total. Apart from the equal split between the parties, an additional sum of £400,000 was given to the wife as to compensate for her relationship-generated disadvantage. That's quite a lot. Point 4. It was said by the judge that it is unusual to find relationship-generated disadvantage that would lead to compensation, but this is one such case, because the wife had received excellent appraisals, which lavished praise and showed an extremely successful career at the law firm. One of the partners the wife had worked with thought she was destined for partnership. Okay? And it was realistic that she would aim for that. It was concluded that the wife might well have become a partner with huge financial rewards that would have been brought to her. So she would have been able to climb up to a similar position financially as the husband, even making more than the husband, perhaps. Okay. And the court also found that the husband did not want the wife to work at the firm after they married. The husband wanted his career to take precedence, and he was supportive of the wife's idea to move in-house. The husband went along and encouraged the wife to give up on a career working at a law firm. So all the sacrifices the wife has made have given her an extra 0.4 million on top of the 50-50. of 10 million. Okay, so the wife succeeded in that case. But in Hong Kong, I'm not really aware of any, there might be some authorities, but I'm not aware of any where you successfully argue for a lot for compensation for relationship-generated disadvantage. Okay. So, but I guess such as in McFarlane and McFarlane, because it's a needs case, then apart from your needs, generously interpreted, you can use this concept to maximize your claim in periodical payment form. Okay, you can try to argue that, but in sharing, it's very difficult to have extra percentage to be added to your side of the balance sheet. Even if you can, it's a small percentage, very likely less than 5%. Okay, and in this case, it was 3%. All right. Let's take a break of maybe. Let's come back at 8:35. Is that okay? And if you have the time during the break, please read the factual scenarios, which would have been printed and provided to you along with the slides today. It's to be used next time, but the reason why I might want to tell you about how LKW and DD is applied in this factual scenario at the end of today's lecture, if we have time. I think we have time for that, okay? So that you can better understand what will happen in the next class. And then you see how LKW and DD is being used, okay? Okay, let's come back at 8:40, give you 20 minutes.